want to talk about this more now as well and continue the conversation. We have constitutional attorney Ronald Chapman. He has litigated in front of the Supreme Court, and he has extensive experience in federal investigations and prosecutions. Ronald, thanks for joining us here at Newsy. You know, it seems like there's a lot of confusion right now on the protections of the First Amendment. So can you start by just explaining what exactly the Constitution says?
Absolutely, and thank you so much for having me. Well, first, the Constitution really applies to govern speech between, or speech regulated by the federal government in this case. And so when we look at content moderation on social media, the First Amendment isn't really the question that we should be asking about. The First Amendment certainly would protect an individual's right to speak and prevent the government from impinging upon that. But there is an act that's important to talk about here, and that is the Communications Decency Act, Section 230, which actually gives these platforms immunity for the things that are said by third parties on them. And so I think when people are talking about moderation, they're talking about modifying Section 230 in this case to maybe require more content moderation.
So that being said, then, do social media companies have a legal responsibility to moderate that content, in that same vein, remove certain types of speech from their platforms?
Certainly they do. They first have an obligation to prevent hate speech, to prevent lewd images from appearing on those sites. And if they're hosting a platform, they have a duty to make sure that those things don't appear on it. But when it comes to regulating the speech of third parties, right now Section 230 is wide open and doesn't require any specific moderation, but simply provides. I think in 2021, Mark Zuckerberg actually spoke in front of Congress, and one of the things that he mentioned was he believes that 230 should be modified to require some reasonable moderation by these content platforms. Thankfully, certain platforms such as Twitter, Facebook, Instagram have been self-moderating and trying to find out where they fit in this moderation cycle, but it's been difficult given the absence of any clear government regulations. Now, I must also mention the government is in a bind here, because any regulation that restricts speech is certainly going to be challenged in front of the Supreme Court as a restriction on free speech, and we could end up with a battle between the federal government's restriction and third-party rights to free speech.
I see. Well, the FCC can take action against companies for hate speech, but how high is that bar before someone is reprimanded, and really how severe of a penalty would we be talking about with the FCC?
Well, certainly FCC penalties can be very severe for communications platforms, and I think that's really the regulation that we're looking at when we're looking at the requirement to regulate speech. If Twitter, Facebook, Instagram fall outside of FCC regulations for the things they push out, they can certainly be subject to punishment. However, 230 still stands in place to protect the speech of third parties and would allow third parties to say certain things on the platform which the public may be concerned with. So certainly some change of Section 230 would be required in this case. It's been around since, I believe, 1996 and hasn't been modified. I think the Department of Justice is looking at potentially enforcing it in a different way, and hopefully we can get somewhere with clear guidance from the federal government on speech regulations.
Yeah, the 1990s, well before social media. Constitutional attorney Ronald Chapman, thank you so much for your insight tonight. We appreciate it.
Thank you so much for having me.